And now, it's The Law Show on CL 650, a comprehensive look at everything you need to know about the law.
Have you seen a trend towards sort of prenups or cohabitation agreements?
Yeah, they went out of, cohabs went out of favor for a little bit based on what our old statute said. There was a section that kind of made things different if you had one.
So what's changed?
Now that it applies to all couples, the Act, the Family Law Act since March of 2013, and the fact that what you bring in to a relationship can be excluded property, people are now wanting an agreement to say, okay, here's what I brought in. I'm fixing the amount and the total and the value now, and how to deal with it if we break up, if it goes into joint names or whatever. You put in a cohab to say, here's what's going to happen if we don't stick it out for the long term.
And this must be common with second marriages.
Oh, yeah,
because
for sure.
you've maybe lived with somebody for a while, you've sold a house, you have a substantial amount of money that you're bringing, or you've inherited money, those sorts of things. There are exclusions anyway, right?
Yeah, there are, but it's better if you have it in paper so that there's no argument later that here's what I brought in. At the very least, it crystallizes what you brought into the relationship.
For example, if you had living parents and they decided to gift you, say, $100,000 to maybe buy a condo or something like that, then you would need to have it written down that was a gift from your parents. It wasn't for both of you.
Exactly. And the agreement would say that this is mine regardless of what happens later on. We may split the balance, but I get the first $100,000 back. A lot of people do prenups and marriage agreements for a second marriage also to protect their children from the first marriage. Because it seems like a lot of the times when they have more money at the second one, they're a little bit older. They don't intend to have any more children, but they want to protect the children from their first marriage.
So you, a family law lawyer, but do you do these as well?
Yes, I do. And they actually form 20% of my practice.
Really?
Because there's a lot of people when they want to get married, they want to make sure that they don't have to fight down the road. And sometimes paying $3,000-4,000 for a cohab in the first place is better than 30 or 40 after to get around what could happen to you.
Is there a cohabitation or prenup that it runs out? Is there a time where it doesn't hold validity?
No, although the longer you're together, the court may look at it a little differently. So if you got a prenup at 21 and you were together for 50 years, the court may say, well, how important is this prenup? You based everything as if it wasn't there. But they don't expire. And it's just whether or not the court finds it to be unfair at the end of the day. So you got to make sure you disclose what assets you have and liabilities, and that both parties get independent legal advice as to the nature of the agreement, and then it should be valid in perpetuity.
And we've talked already about the massive increase in property values. You mentioned $350,000 for a house in Surrey now. 1.3 is not uncommon for a detached home, and we're seeing that trend. And I know some realtors and people in real estate that say parents are giving children money to help them get started. So is that good advice to have all that written down? Yes.
You want to make sure it's a gift letter and it's to the one person only. You'd also want to make sure if the parents say, look, if you break up, I want it paid back, that you have that's covered as well. Because often there's a fight down the road as to whether or not it's a gift or it's a loan. And if there's no paper, they may assume.
Well, maybe when the son and daughter-in-law were getting along, it was a gift. But then one leaves, and now they don't like that person anymore. Well, now it's a loan.
Exactly.
And there's no way to really know the difference.
So if you are the parent giving the money, make sure that it's and you want to say, look, it's a gift, make sure that's in writing. If it's a loan, make sure it's in writing and get either a mortgage or a promissory note or something, just some written evidence as to what your intention was.
Okay, so now agreements about children. I'm guessing this is with pre-existing children from a different marriage, or
no? Agreements respecting children can be how are the maintenance going to be paid, what's going to be paid, what's the guardianship, etc. You can do a written agreement. It's not binding on a court, though. Unlike an agreement with respect to division of assets, which can be binding on a court, the court has the ultimate authority over children, and they call it parens patriae, which really means I'm acting like a parent and I'm protecting these children. And so if an agreement doesn't meet the goals or protects the children and isn't in their best interest, the court can override it. But you can do agreement that says that you and I are going to share the time with the children in whatever manner you come up with, Here's the maintenance that's going to be paid. Here's what the activities are, etc.
So this is in the case of a divorce.
Yeah.
But people don't have these agreements about children before.
No,
Oh.
you can't have a marriage agreement with children that might happen because you can't look that far into the future.